What happens if the winning bidder pulls out after an auction? It's a fair question because auction sales are often assumed to be final, yet the consequences of a buyer failing to proceed aren't always clearly understood from the outset. Let's dive straight in. Just before we get into the detail, it's worth saying up front, what happens after a buyer wins an auction depends heavily on the type of auction you're using. In traditional or unconditional auctions, the seller's legal position is extremely strong. The moment the hammer falls, the buyer is locked into a binding contract. In the modern method of auction, often run by estate agents and auction houses such as ourselves, the buyer has less to lose and more freedom to walk away. We'll come back to that distinction shortly, but let's start with the traditional process first, because that's the foundation of how true auction law works in England and Wales. Unlike private treaty sales where buyers can drift, delay or disappear, traditional auction sales are governed by very clear legislation and contractual rules. So here's the legal underpinning. Under long-established auction law, a binding contract is formed at the fall of the hammer, within the statutory framework set out in legislation such as Section 57, subsection 2 of the Law of Property Act 1925. Section 2 of the Law of Property Miscellaneous Provisions Act 1989 confirms that a property contract must be in writing and signed, satisfied through the memorandum of sale signed immediately after the auction. And there are the standard conditions of sale, 5th edition, and widely used common auction conditions or CACs, which formalise deposit requirements, contract formation, completion dates, interest charges, and remedies for default. We'll add the links to the relevant legislation in the show notes. Now, some buyers don't realise that the law treats a successful bid as an immediate exchange of contracts. There's no cooling off period, no renegotiation, and no subject to survey. That's why auction offers more certainty than estate agency sales, because the commitment happens at the very start, not months into the process. So what does this legally binding exchange mean in practice? At the fall of the hammer, the buyer must pay the 10% deposit immediately, must complete within a specified time frame, usually 28 days, but this can vary. The buyer becomes liable for any breach under standard conditions and the seller's special conditions. And if the buyer tries to pull out, delays too long, or simply fails to complete, the consequences are pretty straightforward. The deposit is forfeited, i.e. released to the seller, contractual interest begins to accrue, a notice to complete is issued, the seller can claim additional costs, losses and damages, and the property can be relisted quickly. This is the strongest buyer commitment framework of any mainstream property sale method in the UK. Now let's bring the modern method of auction back into the conversation, because this is where many sellers get confused.